You can't comment on the particular cases, but would you expect some of those to be confirmed leaks from the IRS of confidential information? Or in the past, have you ever?
Unfortunately, I'm being instructed by counsel that I cannot acknowledge the results of those investigations, Congressman.
Okay. Can you acknowledge results of prior investigations? Can you acknowledge that a leak has ever been confirmed, that anybody's private information has ever been released?
We don't have an answer to that, sir.
Okay. Mr. Chairman, we need more hearings. We need more investigations. We need to get to the bottom of this. I think people working for the government right now need to be fired for abusing the public trust. But let's not delude ourselves. We're just treating a symptom of the disease. And the disease is a bloated, abusive government that has become self-serving. We've seen that Mr. Shulman has stated he can't be held responsible for 90,000 employees. I doubt any man or woman could be held responsible for a bureaucracy that's 100 years old that has that many employees. We sit here comfortably on the dais questioning three men here today, but I think Congress created this monster. We need to look inward. We have 70,000 pages of tax code, 90,000 employees that work for this bureaucracy. And a lot of this tax code is open to interpretation. I think it's ripe for corruption and abuse. And I think in order to restore trust, the public trust, we're going to have to address this issue. And I think Congress needs to take it upon itself after today to shrink the size of the IRS, to simplify the tax code, and to restore the public trust. Thank you, and I yield back.
We now go to the gentlelady from New Mexico, Ms. Luan Grissom. They're not tax deductible. This is about the entity not paying taxes, as I understand it. If you're declined a 501c4 status, some of these organizations, 3 years, under certain circumstances, you then have to pay corporate taxes on this as though it was income. You then could even have your officers and directors personally responsible. But it's not a C3. These are C4s, and I'm sure that we have people here that could define the difference. But it's real important to understand this is about if you were, for example, were determined to be a 527, nothing would change, except, as you said, the potential names. 501c4s, 527s, the difference is not really a taxable event.
Mr. Chairman, I appreciate that clarification. However, if I'm not clear that some of these organizations provide the right disclosures, I'm not clear that folks who are providing donations to those organizations are clear about those rules, I'm not clear based on the scope of this investigation to date that we've got clarity about whether folks really are qualified as a 501c3 or a 501c4. And as we uncover more information about those donors, those differences, those investments, and the engagement of activity of these organizations, it seems to me, if there are violations made, the disclosure of donors in a violation and taxes be recovered, if they so apply, should be done by the IRS.
I appreciate the gentlelady's comments. Would somebody clarify for the record the taxation policies so that that could be clear? Because I think there's Mr. Shulman, you certainly know the difference. There's obviously a huge misunderstanding as to the taxability and the ramifications, what you really get on a 501c4 versus 527.
There's a chart actually in the Inspector General's report, I think, that has the different taxable entities and the different.
Right. I mean, 501c3 is a big deal. 501c4 less. Mr. George? To the extent that you can answer to clarify for the lady.
Yes, oh, certainly. A 501c3 may do the following. They may receive tax-deductible charitable contributions. They may not engage in political campaign intervention. They must publicly disclose the identity of their donors. I'm sorry, they may not disclose the identity of their donors. They may engage in lobbying, limited but must not be substantial. They may engage in general advocacy not related to legislation or the election of candidates, but it has to be as an educational activity, and they must apply with the Internal Revenue Service for their 501c3 status. Now, as to 501c4, 5, and 6s, no, none of their contributions are tax deductible. They may engage in limited political campaign intervention, but again, it may not be their primary activity. They do not have to disclose the identity of their donors. They may engage in lobbying, but it has to be actually they have an unlimited amount of ability to do that if it's in furtherance of the tax-exempt purpose for which they were established. And as it relates to general advocacy, they may also do so in an unlimited way, as long, again, as it's in furtherance of their tax-exempt status, and they do not need to apply to the Internal Revenue Service for this status.
Thank you. The gentlelady, I presume, is satisfied.
I'm not, Mr. Chairman.
Well, we'll make additional information available, but I
Can I
think
make
it's
one statement, Mr.
Of course.
Chairman? Thank you so much. To the issue that in a 501c3, which I'm clear about the differences between, and I appreciate doing that for the record, sir, 501c3s and 501c4s, donors are not required, you don't have to, the 501c4 doesn't have to disclose the donors.
Right.
If they have violated that political activity premise, just like a 501c3, I'm making the argument here that they should have to then disclose those donors. And now that you're disclosed, I want to make sure that appropriate taxes have applied to that person's personal income as a result of knowing that they've made contributions that were not disclosed in any form, so that there is a double check. In the same way that the IRS receives independent information about my income, what I receive and what I don't receive.
Well,
That's my point
the
here,
gentlelady
Mr.
may
Chairman.
turn the tax code upside down if she would like. I suggest you find co-sponsors, but the fact is that these individuals give money post-tax. They pay their taxes, and then they give the money out, and they do not control the organization. So the idea that they would take on personal responsibility for their contributions and somehow be double taxed, perhaps the gentlelady would reconsider the chilling effect, whether it's a 501c3 or 501c4. With that,
Follow up on some of your line of questioning there as it relates to, I want to make sure that I understand you, Mr. George, on May 29th of 2012, almost a year before the official report came out, you were briefed, and as my understanding, you specifically knew at that particular point that there was a criteria that was being used to target the Tea Party Patriots 912 group. Is that correct?
Actually, sir, that was my final briefing on this matter. During the course of the audit.
Okay, but this is May 29th, 2012. Is that correct?
That's correct.
All right, and so on May 30th, the day after that, you actually briefed Mr. Schulman, Deputy Commissioner Steve Miller, and Beth Tucker on this new audit, and using that same criteria that it was being used against Tea Parties. Is that correct?
Sir,
That's what your notes say.
Yes, but my colleagues behind me who were in attendance at the meeting.
Right, it said function heads, so I assume that they were your function heads.
And they indicated we had some indication at the time that the allegations had merit, but we did not characterize, we cannot, I'm not in a position now to characterize the level of detail that we had at that point.
I'm not asking about detail. Was there a separate criteria used for those groups? A separate criteria used for Tea Party groups that you just admitted to just a few seconds ago?
Again, sir, I'm not certain as to exactly.
Well, as your function heads, are y'all familiar with it? We have notes that would indicate that there was a separate criteria used.
Yes, sir. I was just informed that we knew there was a criteria. We didn't know the nature of the extensiveness of it, sir.
So we know that it was separate, though.
Yes.
And you, the gentleman to your left, you did notify him of that on May 30th of 2012.
That is my recollection.
Okay. Then on June the 4th, this note says that you briefed the general counsel, Mr. Chris Meade. So you briefed him of a separate criteria in the Treasury Department on June the 4th, 2012. Because all of a sudden, all of this is supposedly it's just happened, but this is well over a year ago. So you briefed the general counsel, the chief general counsel of the Treasury Department, well over a year ago.
I did, but I have to acknowledge that in the briefings that we hold with the Commissioner of the Internal Revenue Service, I have my subject matter experts in the room.
So you went by yourself to the general counsel, and so you may not have given them the complete story.
I'm certain that I did not give the level of...
Why would you have not given them the complete story if you had just done it a few days before?
Well, because the Commissioner...
The document that you've given us. It was in the document that you've given us, so are you just giving us stuff that you're not aware of, Mr. George?
I don't know which document you're referring to, sir.
Well, I'll be glad to give it to you. I just find it highly inappropriate.
Sir, this was put together by auditors, as you can see, some of whom are in Washington, many of whom are in Washington, but some of whom are not. These are level.
Well, that's my point. This is not isolated to two people in Cincinnati. This has a whole lot of people in Washington, D.C. And why would she have been part of it? Would you normally conduct an audit in that manner?
You know,
The gentleman's time has expired. You may answer that.
Congressman, I would respectfully request the opportunity to look further into this and to report back to the committee, because this is the first time that I was made aware of this, and I really don't have information about it.
I thank the chairman.
Thank you, and we will allow the gentleman time to do the research and get back with us. We now go to the gentleman from California, Mr. Canaris.
I don't know the answer to that question.
Yeah, the answer is no. I understand that they take training classes on ethics, but specifically about the Constitution and Bill of Rights, you don't know that. Given their power to destroy businesses and audit individuals, do you think it would be useful for the IRS to require all of its employees to take a class studying the Constitution and Bill of Rights in order to make positively sure that they understand the concept of government restraint created at our founding?
I think it's very important that IRS personnel be well trained.
Did you study the Constitution? You're a lawyer, are you not? Or an attorney?
I went to law school.
You went to law school. Did you study the Constitution?
I believe I took constitutional law, but I'm not prepared to take an exam at this time. Meaning, I'll answer any of your questions, but I can't promise, I'm an expert.
Expert. Well, you know the First, Second Amendment, and one of my favorites, the 19th, right? You know those.
Excuse me?
You know those
I told
amendments.
you I'm not.
Excuse me, the constitutional amendments. You know the first, you know the second, and you know the 19th.
I don't necessarily have the Constitution memorized, sir.
Okay. Well, they're pretty general. I mean, in what each one is. Like First Amendment is freedom of the press, freedom of religion, and freedom to petition the government for redress of grievances. First Amendment, right?
I really can't recite the Constitution, sir.
Okay. Do you understand do you know what the word T in Tea Party stands for?
I do not.
It stands for taxed enough already. That's contrary to what the IRS wants, I think, because they want to tax as much as possible, don't they?
The IRS's job is to administer the tax laws that are on the books.
Mr. Chairman, I yield back my time.
Would the gentleman yield?
Yes.
Just briefly, I want to make sure this gets properly in the record. Yesterday we had a transcribed interview, and I'm going to ask unanimous consent to place at this time pages 189 and 190 in the record, without objection so ordered. And I would just read very briefly from it. This was to Ms. Paz. When we asked her about, did you ever accompany any other employees to their interviews with TIGTA? And she said, yes, I sat in on all the interviews, but the arrangement we had worked out with TIGTA was that I would leave at the end of the interview so they could ask anyone interviewed any questions they wanted to ask without anyone else present. So that was done. If that's correct, that her testimony that she was in at least what she thought was all the interviews, and that she left for a short time at the end.
I've been informed by staff that that is accurate, sir.
Thank you. And we went on with Mr. Hickson, one of my staff attorneys, asked, and he is an attorney, he didn't just go to law school, how did that arrangement come about when TICTA approached you about conducting their audit, did you request that you be present at all the interviews? Ms. Paz answered, yes, I believe, ... I can't remember if I made the request or Lois Lerner made the request, but we discussed that in order for the IRS to be able to respond to the report, we had to understand what information TICTA had and what they were being told. Mr. George, you're a seasoned investigator. Those individuals who did that on your behalf, is that routine to basically let the target of an investigation/audit sit in so they know the questions and answers when they later may be a target of misconduct?
The operative word, Mr. Chairman, is audit.
Okay, so I'm gonna stop you there.
Yes.
Because this was an audit, it was conducted much more, if you will, like people coming in and just going through the books to find out, you know, how much more taxes you owe, right? It wasn't conducted as an investigation.
That's correct. It was not conducted as an investigation.
Okay, I'm going to conclude later during the last 5 minutes.